Hi, and welcome to Jill Pearson Profiles. I'm your host, Jill Pearson. Our viewers know Wendy Murphy, who has already done 3 shows with us. Wendy is a legal analyst on many national TV shows and an adjunct professor at New England Law Boston. She's an impact litigator who specializes in representing victimized women and children. Wendy has authored 2 books, many chapters of other books, and is a regular columnist for the Patriot Ledger. She's been a visiting scholar at Harvard Law School. Her 2007 book, And Justice for Some, is about to come out in an updated paperback edition. And Wendy is here today to tell us about those updates. Wendy, thank you so much for joining us again.
I'm glad to be here.
So you've been specializing in rape victims issues for a long time.
Yes.
What issue do you say in your new edition most undermines rape victims' access to justice?
Well, I'm so glad you asked because there's a lot in my book, but I have a soft spot and a really, fierce commitment to this category of rape victims because in my experience, both having been a prosecutor of those kinds of cases 25 years ago and as an academic, I've been teaching a seminar on sexual violence for over a decade. It continues to shock me and motivate me that we so bluntly treat rape victims with less equality in the legal system and less fairness compared to all other victims of all of other kinds of crime. And I'll tell you what I mean. But it's as simple as if your house gets robbed and you call the police and you report the crime and they and you go through the trial process, generally speaking, victims of that kind of crime come out of the process saying, oh, I'm so glad that the justice system worked and that justice was served and the police were so nice to me and the prosecutor was so nice to me and the defense attorney was okay. And nobody who's been raped leaves the legal system feeling that way. It just never happens. And for me, it's always been a kind of a challenge to try to create more equity, but also to unpack some of the reasons why. So to answer your question more specifically, in 20 years plus, looking at that, why is this happening problem? Why do only 2% of rapists spend even one day behind bars? Why do victims of this crime systematically report suffering more harm by participating in the legal system? How crazy is that? Where does that come from? I can tell you that the single largest explanation, the single largest problem is that unlike all other kinds of crime victims, rape victims are expected to submit to systemic intrusions into their privacy. What do I mean? I mean that if you're a rape victim and you testify, report a crime and agree to testify in almost any state in the country, it's highly likely you will be forced to answer questions about your past mental health history, your past sex life, your past use of drugs or alcohol, your character, even though those things tell us nothing about what happened on the night in question. And even though you can be a perfectly sane rape victim and go through the trial process and people are asking you if you have mental health problems, and you can be a completely wacky victim of robbery and nobody asks. It's that blunt that you could be a robbery victim with a big mental health problem in terms of your credibility as a human being, and we leave you alone because we accept and understand that people of all types get victimized. In fact, sometimes people with mental health issues are disproportionately vulnerable to violence such as robbery and so forth. We know from the Department of Justice that people with disabilities are more likely to suffer all kinds of criminal violence because they get targeted by the bad guys. So the fact that somebody has a mental health problem really isn't relevant. Nevertheless, we leave people alone generally because we know that it would be a bad idea to indulge the concept of, well, those types of people should have a tougher time achieving justice than the fully abled people who go, to graduate school at the fancy college. So because we want justice to be equally handed out to people who suffer, we're very careful not to make judgments in some kinds of cases. But rape victims, because they come to the process chock full of all the baggage we impose on them as a culture that comes from a history of thinking about women generally as mentally ill, not as credible, vindictive, willing to lie, to get back at the guy, because those cultural myths walk into the room with the woman when she reports any crime, particularly a crime of sexual violence where she's naming a man as the perpetrator. She comes in with all kinds of marks against her. And we indulge rather than protect her against them by saying, well, you know, the jury's going to want to know if you're crazy. The jury's going to want to know if you have a history of being vindictive. The jury's going to want to know. The defense is going to want to know. And my response, even as a prosecutor many, many years ago, which was perhaps naive, my response was always, why are we asking her this? What does that have to do with this case? She reported the crime. You know, the guy admitted it. The only defense in most cases is she consented. How does her, you know, having had sex with 400 gorillas tell us anything about whether she consented on the night in question? Why are we asking? So for me as a prosecutor, when I saw that problem, that disparity in treatment, it was really, if I could describe it, the systemic willingness to force a woman reporting a rape to unveil things about herself that told us nothing about the crime, did nothing to elucidate the truth, and in fact caused her pain and suffering, and sometimes gave a strategic advantage to the other side such that either the victim would walk away from the case or be very happy to take a plea bargain. So, you know, the guy would say, instead of pleading guilty to rape, I'll plead guilty to spitting on the sidewalk and I'll take a year of probation. And the victim would say, oh, thankfully, I'll take anything because then I won't have to go through any more of this. Well, over the years, what I've seen is not only an increasing trend in that direction, which I'm not sure I can explain why it's gotten worse, except that in the criminal justice system in particular, we have, you know, the case between the government and the defendant. And the defendant has a lot of power and status as a party to the case, and the government, you know, speaks for the people, and the government's job is to protect not only victims and society, but also the rights of the accused. Well, when bad things happen to the victim and everybody notices that she's not a party to the case, she's just a witness. So she doesn't have any status, she doesn't have a lawyer, she has no say, she doesn't have a role, a natural party role in the process. It's like an invisibility problem. So if we keep doing harm to her and it produces benefits to the perpetrator, and she can't complain, not that she's not upset, but she has no voice. She has no seat at the table.
She has no standing in the courtroom.
No standing, no voice, no seat at the table. So it's an invisibility problem. And the more the system benefits from causing her harm, which is to say the more the bad guys who do have power get lower sentences and don't get charged or have charges dismissed or win not guilty verdicts by beating up on the victim, you know, the more the system allows it to go further and further and further. And it has gotten so bad that although I told you that I would categorize the problem as these intrusions into private space, it has gotten so bad that in one state and I'm involved in a case where this concept has really been pushed to the max, and I'm outraged, and I'm going to file a class action lawsuit against the state court that allowed this. A little girl, teenager who'd been brutally sexually violated over a period of years, was ordered by the court at the behest of the perpetrator who confessed to submit to a forced penetrating genital examination so they could conduct discovery of the inside of her body. Yeah. So, in other words, she's been subjected to rape in the name of justice as a price for reporting crime and participating in the legal system. I mean, we want people to come forward and report crime. We want them to do their civic duty, participate in the legal system, tell the truth, help us keep the world safer by testifying when it needs to be done so that the bad guys are off the streets and get punished, and that helps us be more civilized to one another, and it creates law and order. Well, you know, you'd almost expect, if you landed here from Mars and you watched how the system treats rape victims, you'd say, well, you mustn't really want to stop rape. That must be one of those crimes you really don't want to stop, because why would you do this? And so, in my book, I write a lot about the various ways in which we punish women for speaking out about violence against their bodies, punish women in family court for having the audacity to speak up when their children are abused by the father. I write a lot about why we aren't outraged and why we don't mobilize better, and why are we complaining in silence and isolation? Why have women not found a space to work together, to protest, march in the streets? I mean, do whatever. If we treated victims of home invasion the way we treat victims of rape, home invasions would be epidemic, because nobody would worry about breaking into homes and stealing stuff, because there would be no repercussion.
Well, why do you think women have not banded together to do something about this?
Well, I think part of the answer to that question is just a culturally complex one. We're still stuck in a historical legal mess around what women have as true equality. I mean, it hasn't been that long since women have even been citizens. Women couldn't sit on juries in Massachusetts until I want to say the 1960s or 70s. It wasn't that long ago. And, in terms of the history of rape law, until relatively recently, men couldn't be charged with rape of their wives because they owned them in some ways, not in a direct slave-like way, but they owned them enough and had enough control over them, especially after marriage, that it was not a crime to rape a wife. So because we still have that ownership stuff in the law, it's hard to get out of that. But separate from that, women as a group, women as a class, when you think about political mobilization and the things we care about, we are so divided as women about how we feel about this issue. I mean, I think we're completely, what's the right word, manipulated by the existing political system. So we're made to believe, for example, when an election comes along, that we should vote for the Republican or for the Democrat based on how they feel about free contraception. And that gets spoon-fed to us in every newspaper as the issue we're supposed to care about. I said during the last campaign, I don't care about free contraception. It's not the real issue. Dead women don't need free contraception. And women are dying in huge numbers, and they're not struggling because of a lack of free contraception in the same huge numbers. And the problems from a lack of free contraception are not the same as dying and being raped. So the political system is a problem. But the real problem, in terms of direct advocacy around this issue, the mistreatment of women in the criminal justice system, in their capacity as victims, can be tied to the fact that an awful lot of women with power in the criminal justice system are criminal defense attorneys. They have so much power to exploit these problems that when they speak and they say, I'm a female and I think it's okay for me to use my client's rights to squash this victim like trash in the name of justice, to violate her privacy gratuitously for no purpose except for tactical advantage, to make her feel like crap so she won't be able to survive the trial. Because I can do this in the name of justice and I am a woman, it must be okay for women to accept this. And I have to say, this particular fight has been so painful because, for me in my career, because I see these powerful women's rights advocates who wear this hat sometimes as the criminal defense attorney, and they talk out of one side of their mouths at the Women's Bar Association meetings and so forth and say, well, the legal system really needs to be much more fair to women. And then they're over here representing their guilty rapist clients and indulging the very things they're complaining about. And they use their gender to quiet the criticism that I bring to bear because they have the capacity to speak from a different voice about their client's interest, and it's constitutionally necessary. We're so sorry, Wendy, but I have a constitutional right to commit gender discrimination and disrespect this victim because it'll help my client win. As if winning one man's freedom can be justified by disrespecting and subjugating an entire class of human beings. That's what women defense attorneys say to me. And one famous one, Nancy Gertner, who until recently was a federal judge, was before that a criminal defense attorney. She's now teaching at Harvard Law School. Nancy Gertner was personally involved in a really important case of mine some years ago where she used her status as an advocate for women's rights and women's equality to covertly interfere in a case of mine where I was about to make, through this appellate decision, make a big change in the law to protect women's rights. She used her status as a woman to get the National Organization for Women Legal Defense and Education Fund to allow her to write a brief that they wanted to write to side with me. She wrote it, made it sound like it was great for women's rights, filed it in the Supreme Judicial Court, and argued that the woman should lose and that the rapist should prevail and that the law should be bad for women. And I thought, what planet am I on that this woman, representing a national women's organization, would take this step, use her gender, exploit the National Organization for Women's Power, and ask the Supreme Judicial Court to subjugate women, to discriminate against women, to violate women's privacy for no purpose.
Now, that was the Stockhammer case that you're speaking of.
Yeah.
It's a famous case in Massachusetts.
Yeah.
And what was at stake when you were arguing in the Supreme Judicial Court?
So Stockhammer came from this case involving a man who was a student at Brandeis University and was accused of rape in a case where Nancy Gertner was asked to represent him, but she at the time said, I don't represent rapists because the system is unfair to women. So she had her partner represent them at trial, and on appeal, because he was convicted, Nancy took over. What she argued in the Stockhammer case that made bad law, and it literally created this infamous ruling called the Stockhammer ruling that you mentioned, what she argued was my client's conviction should be overturned because the defense did not get automatic access to her therapy records.
The victim's
therapy records.
Mental health records.
That she sought treatment after the crime. The judge in the case actually brought the records in and looked at them at what was called a private or in-camera review screening. The judge looked at them and said, there's nothing in here. I'm not going to let you see her records. Nothing in here has anything to do with this case. Well, Nancy argued on appeal that letting a judge privately review these records violated her client's fair trial rights because she should have been allowed to look at them. She has this really critical eye of a defense attorney, and she can find things that maybe the judge couldn't find. Well, the SJC said, when the case finally landed there, the SJC said, well, you know, we looked at the records too. There's nothing in there. Nevertheless, we're going to change the law. Per Nancy Gertner, feminist activist, per Nancy Gertner's request, we're going to change the law. And henceforth, because of the Stockhammer case, henceforth, anytime a rape victim has any kind of files of mental health care or whatever, if the defense wants them, we're going to take them right from the therapist's office and give them to the defense attorney to snoop through and see what they might be able to find. That was such a horrible ruling that, and I was a prosecutor at the time, and I know that prosecutors would say to victims, I'm sorry to tell you this, I know you've just reported a rape, but you're going to have to list everybody you've ever spoken to about anything, all of your counselors, all of your therapists, everybody. You got to list them all, and the defense is going to send summonses, and they're going to get piles and piles of your stuff.
And all your medical records.
All your medical records, all your mental health records, everything. School, everything. And I remember I had a case at the time where a rape victim didn't even find out the defense got her medical records until she showed up at trial, and the defense had a big box of them, and it included her mammogram from years before the rape. She was she was devastated. And it's just such, it's such a simple concept. You don't do that to a person who's already suffered. You don't violate their rights gratuitously for no purpose. This is important, constitutionally protected, privileged material. You don't just go willy-nilly through this stuff because a person was raped. But Gertner did something even weirder. So after the Stockhammer case, she set off to go and become a judge, a federal judge. She wasn't yet a judge when I left the DA's office and then went about to try to create a good test case to fix the law. I said, I'm going to go find a good test case. I'm going to challenge this as unconstitutional. I'm going to file an appeal, and I'm going to say to the SJC, you can't do this to people. And, so happens I got a good case together, and it was on its way up to the SJC, and I could tell that we were probably going to prevail because there was a lot of favorable attention and people were on our side. I had national women's groups all over the nation supporting what we were doing, and I called the National Organization for Women Legal Defense and Education Fund and said, would you sign an amicus brief, a brief separate from mine but that supports my position? Would you file a brief in the case saying this is important to protect privacy rights for these victims? They said, yeah, we definitely want to help you. So I'm ready to file, and I go up to the court, and I'm literally at the bench waiting for the justices to come out so I can start arguing the case, because I could tell we were going to win. I just knew it. And lo and behold, Nancy Gertner sends somebody to the court, and they hand me a brief filed by Nancy Gertner on behalf of the National Organization for Women Legal Defense and Education Fund. And I'm thinking, what? Nancy Gertner, the defense attorney who would fight tooth and nail against me winning the overturning of her Stockhammer case? She wrote a brief for the NOW group that promised to support my position? What? Of course, I couldn't read it before the argument, but after the argument, I read it and I thought, oh, this is interesting. It says a lot of good things about women are treated unfairly. The last page, therefore, the Stockhammer ruling should remain and defendants should have automatic access to victims' privilege files simply for the asking. Ta-da! And I thought, this is scandalous. I couldn't believe this happened. I called the NOW people and said, are you kidding me? You said you were going to write a brief for my side. You wrote a brief for the perpetrator. Oh, really? Oh, we'll talk to Nancy because she's on our board and she told us this was the right kind of brief to submit, blah, blah, blah. A couple days later, Nancy asked to have lunch with me. And I go and, I'm like, I know what she's going to ask me. She's going to ask me if I will allow her to modify it or something. I go to lunch and she asks me, oh, how about if instead of withdrawing the brief in its entirety, which is what I said to NOW, you pull that brief. That is a hurtful brief to our cause. You lied. Pull that brief. And if you don't pull that brief, I have 100 organizations around the country that will never support you again. And I got a list and they all signed. I got a long list of every important women's and victims organization in the country to all sign a letter telling NOW you pull that brief. That is despicable what you did. So they tell Nancy, I'm going to pull the brief. She says, oh, let me have lunch with Wendy first. Wendy, how about if instead of arguing this and I argue that, or I'll withdraw this page but not that? I said, no. How about if I'll argue that you have to make a strong showing first before the file goes from the therapist right to the defense attorney? No, Nancy, pull the brief. I left lunch. A few days later, I got a notice. The brief has been pulled. She had to write a letter to the court saying, my client does not authorize me to file this brief.
Her client was the
National Organization for Women. My client has told me this brief is not authorized and it must be withdrawn. And what's interesting is, so I did win the case some months later. They reinstate this process of judges doing private screening. She was furious, and I don't care. But what's interesting is at the time, she was up for a federal judgeship. So the Lawyers Weekly covered the case and said, in its news story, oh, here are the lawyers who wrote briefs. And they included Nancy Gertner for the National Organization for Women, because even though she withdrew it, the court reporter still had a notation that it was on file. Well, a month later, when the formal final decision was published, her name was gone, because she must have noticed that it was there when the preliminary decision came out. And Lawyers Weekly called me and said, why did Nancy Gertner's brief get pulled? And I said, oh, gotta ask her. Why don't you ask her? Because I wanted her, in some ways, I wanted her to become a federal judge. We need more women on the bench. As much as she's a horrible women's rights advocate in rape cases, getting her on the bench in a federal court wouldn't really hurt my work, because most rape cases are in state court. Plus, I wanted her out of my business. She was ruining my cases. Get her on the bench and away from me. So I didn't want to undermine her chances. Anyway, they wrote a story which is very funny and kind of famous in its own right. Their story the week later was entitled "The Nancy Withdrew Mystery." It was great. And I never told them, and I think this is the first time actually I've publicly told this story, although it's going to be in my book. She really worked hard to destroy victims' privacy rights, and she was unsuccessful, and I think she feels great shame about that. I fought really hard, and so this goes back to your question, why is it so difficult for victims, and why is it so difficult for women to get it together and work together on these things? And I think the answer is in part, people like Nancy Gertner can't seem to understand the importance of bonding with other women around the importance of protecting against this unfair intrusion into privacy in a way that denies women equal access to justice. People like Nancy Gertner know that they're causing a divide in women, and they don't care because they care more about perpetrators' rights than women's equality.
And just to wrap up that one part of the subject, Nancy Gertner has written a book.
Yes, yes, she has. I heard she has. It's interesting because although I haven't read it, I know that some of this story must be in there because I ran into her in a green room and she put a sticky on the page and I saw that my name was in there. I didn't read it at that moment. But I later heard from a friend of mine who teaches at Wheelock College that Nancy had guest lectured at her class and had told her class that she worked to help change the law to protect privacy rights for victims. And I said, what? And the way it was described to me, it sounded like Nancy had an epiphany, that like she had won the stock camera case, then she felt bad about it, so she worked hard to fix it, which is such a joke. And I don't know if that's what she wrote in her book because I haven't read it, but I'm told that's what she told the class was in her book. And if that's there, man, that's just a big fat lie because she tried so hard to stop my work from being successful, and she failed. And she lost that fight to keep the stock camera ruling in place, and she was furious. She was absolutely furious. And I don't think she should be entitled at this point to say, oh, I care about women's rights and I felt so bad about stock camera, I fixed it, because she didn't. She tried to keep it in place and she lost the battle. And she deserves to be criticized for that, and she should apologize, frankly. I think she should just tell the truth, apologize, and find a way to bring women together on this, because she knows that what I'm saying is true about how rape victims are unjustly treated. Even Susan Estrich, one of her friends who's from this area, a law professor at USC, does the same thing. Oh, I care about women. She wrote the book Real Rape. She also advocates that perpetrators should have automatic access to privileged files. Mind you, she doesn't think that should work for the victims of home invasions, nor does Nancy Gertner. Neither of them thinks perpetrators of robbery and home invasions should have automatic access to victims' therapy records. Only rape victims, only rape cases, and they claim to be advocates for women's equality. This is my problem. They are very big names, they're powerful women, and they are not only devious about how they do their work, because they're so welcome in the circles of women's rights advocates, they get away with causing harm because it's hard to see it, it's hard to notice it. They talk a good talk, and then they do these insidious and really devious, covert things. But lots of advocates aren't as smart as they are. They're not as educated, and they just go, oh, Susan Estrich, Nancy Gertner, oh, they must be right. And they're telling us this is the way it must be. Yay, let's do what they tell us. It's partly a lack of education in our business of anti-violence activism, and it's partly that they are so beloved by the left, frankly, and the pro-defense lobby and all the power that brings together, that they get lauded and celebrated in the press, even when they talk about caring about women's equality, because people know that ultimately they are supporting perpetrators' rights and selling out, in a sense, selling out their gender to advance that disparity in interests and to subjugate women's equal access to justice. They get celebrated for it because women really don't have the same power to influence public opinion, especially in their capacity as victims of violence. They don't have the same capacity to influence spheres of power as they do. It's really sad.
Wendy, thank you so much for being here.
pleasure.
And I know we had another subject we were going to talk about that'll be in your updated paperback book.
Yep, the John Benet Ramsey case. I'm going to come back and talk
All right,
about it.
if you promise.
I
okay.
promise.
So thank you all for watching today. If you would like to suggest a guest for our show or tell us what you think, you can email us at pearsonprofiles@gmail.com. And until the next time, be well.